Good evening, Crime Talk aficionados. My name is Scott Reich. This is Crime Talk. This is our Tuesday night live after dark. Thanks for watching. Have we got a big show for you tonight? Okay, a couple of things that I want to touch on first and foremost is what we discussed in our video that we put out earlier today. The prosecution has finally got around to filing motions to do consumptive testing for DNA in the Daybell-Vallow Chad Daybell case. Okay. Now, just give you a little perspective. There is a trial date for Daybell-Vallow and Chad Daybell. It's set to commence in January of 2023. Okay. It is now July 19th of 2022. So we're almost to August here. They've got 4 months until we start trial. A little perspective. Do you know when Daybell-Vallow was first charged as it related to the disappearance of Tylee and JJ? Any guesses off the top of your head? May of 2020. No, I'm sorry. I take that back. Sorry, I got my dates confused. The date that Daybell-Vallow was first charged regarding the desertion charges, the abandonment of Daybell-Vallow for Daybell-Vallow as relates to her children, Tylee and JJ. February of 2020, ladies and gentlemen. February of 2020. Daybell and Chad Daybell were indicted in May of 2021 for the homicide charges of JJ and Tylee, as well as Tammy Daybell. Indicted May of 2021 for this case. And here we are. The attorneys for the state of Idaho. And then this particular motion was filed by Lindsay Blake and Rob Wood. And it's the brief in support of motion for consumptive testing of forensic evidence. Filed officially July 18th. It just made it to the file today because apparently it's not so time sensitive. The only motion that is somewhat timely for the public consumption. Now, what does it really matter? Scott, they've got 4 months. How long could it possibly take? It's a death penalty case, ladies and gentlemen. They've known it was going to be a death penalty case going back to May of 2021. There have been issues about testing. There's been conversations early on in the case about DNA evidence, and they were going to do it. Well, guess what? They could have done the consumptive testing way back then. They knew this was a trial case. They knew this is what they refer to in the legal business as a GORT case, G-O-R-T, guilty or trial. The only thing that they're going to, give up is the only thing they're going to give the defendant is a fair trial. That's it. So why wait that long? Okay. Now, the prosecution doesn't really give it. It just basically says, hey, we've got a couple of items that they want to do the consumptive testing on. And they filed this motion in support of it. It's hairs on duct tape inside a body bag reported by the Rexburg police to have been used to transport the remains of JJ-Vallow, and the evidence is identified in reports number 13, and specifically items 11.16. A ridge detail on the adhesive side of tape reported by the Rexburg Police Department to be associated with JJ-Vallow's body as described in the above for trace touch DNA evidence. So basically what they're looking for is there's, as I understand this, there's some adhesive tape and they're looking for some sort of fingerprint on there. Maybe somebody that had to reach and, or DNA evidence, and they have, trying to tear duct tape apart. Sometimes it can be difficult to do. And there could have been some DNA transfer. Then third item, small dark spots on the handles of a shovel and pickaxe reported by the Rexburg Police Department to have been recovered from the garage/barn. And it says here, the state does not intend to consume each of these spots, but to consume a sufficient amount to determine if they contain human DNA and basically to create a profile. And that's identified in report 10. And let's see, there was one more here. Yeah. Fourth, a swab of tape areas associated with items 11 and 13. And then swabs reported by the Rexburg Police Department to be from J.J. Vallow's right hand fingernails and reported to have been obtained during his autopsy. This evidence is identified in report 13. Pretty straightforward, right? Now, I get the prosecution. They don't want to destroy evidence. And that's the argument that would be made. If enough evidence wasn't available so the defense could conduct their own investigation or retesting of these items, then there could be a problem. Then they could say, well, you're not going to be able to use it. But everyone's acting like this is a big deal, and this situation has never come up anywhere. It comes up all the time, and I'm not sure why they're jumping through the hoops that they are, trying to make it seem like a much bigger deal than it possibly is. Apparently may not have been done that much in Idaho because they're citing a bunch of case law from a bunch of federal jurisdictions. And it's, like I said, it's a relatively simple process. Judge, we have some items. They're going to be consumed in DNA testing. The defense will not be able to do that. We understand that creates potential issues, that they won't be able to recreate it. But here's what we're going to do. We're going to coordinate with the defense. So if they want to have their experts show up, observe the process of cutting the DNA items out, doing the little swab test that they do, sticking it in the machine, and developing this DNA profile, they're more than welcome to come and watch. In fact, the DA filed yet another attachment to their motion for their brief in support of motion for consumptive testing. It is an affidavit of a lab technician, a Rylene Nolan. She is a laboratory manager in the Idaho State Police Forensic Services in the Meridian, Idaho branch. She's been employed with him since 2002, and she is the laboratory manager since 2014. Qualified and proficient tested biological screening analyst, and she has been qualified in biological screening since 2003, and she is currently qualified and proficient tested DNA analyst, and she's qualified as a DNA analyst since 2005. She DNA casework analysis in STR is part of the Meridian Laboratory scope of accreditation. And they talk about what they're going to test. Same thing, so I'm not going to repeat them that I previously stated. And she goes on to explain that I affirm these items would be consumed during analysis. I affirm hair roots have 3 phases of growth: anagen, catagen, and telogen. Hairs in the anagen and catagen phase may be suitable for nuclear DNA analysis. Hairs in the telogen phase are not likely suitable for nuclear DNA analysis. I affirm, per the current ISPFS biology/DNA casework analytical methods, revision 9, the entire root end of the hair is required for DNA extraction. It is not possible for our laboratory to sample half of a hair root. And she goes on and gives a little bit more about DNA analysis, and that she is qualified to do so, and that she's not doing anything nefarious with the evidence in any way. And we would have to take Miss Nolan at her word, and the court will, in fact, do so. And if the defense cannot produce their own DNA experts, then they're going to have to wait. But here's the thing. Sometimes, I don't know what kind of budget Chad Daybell is working with. DNA experts, they're expensive, all right? I mean, it's not crazy. Usually you can find them at the, biology professors at local universities that can review this DNA stuff. They can look at the numbers. They've run the tests. They know how to do it. But then you get them to review it, analyze it, testify, see if there's any issues whatsoever. It's expensive. So a lot of times people wait for the test to be done, and then you go back and you look and see if there are any errors in the testing process. There's these little scales that come out. It looks like an EKG machine, a little blip, and that's an allele, and that's something that they use to identify it. I'm not claiming I know what it looks like All I know is I get the results, I deal with them, and then you have to hire an expert to look at them. Now, this particular evidence does not strike me as something of great significant value, with a couple of exceptions. Okay. When it comes to the small dark spots on the handles of a shovel and pickaxe, yeah, let's say that it appears to be a blood like substance on the pickaxe handle, and they test it and they say, yes, it is in fact blood. And maybe they have enough to get a DNA sample. Okay. You find out it's Chad Daybell's shovel/pickaxe. Okay. The defense gets up and asks questions. Miss DNA expert, you found DNA there. You found it to be blood. You tested it, and it turns out to be Chad Daybell's. When did that DNA sample get there? I have no idea. You can't say if that was used to dig up a tree or whether it was used to bury the remains of JJ and Tylee. No, I cannot. I have no personal knowledge of that. All right. Thank you. Next item down. Now, the hair and the duct tape, that could be interesting, but it could be a hair from JJ. It could be a hair from Tylee. So it may not be anything of evidentiary value. Obviously, if it's a hair of somebody else, that would be significant, which makes me wonder why like we just started when we started our conversation, why did it take so long to get this done? They knew that this was going to be testing. I understand that state labs are busy. They have to prioritize. And they usually wait until there has been a trial setting. But there's been a trial setting now for months in the Daybell-Vallow Chad Daybell matter, assuming you look at Chad Daybell's case since it was set first and then joined. But the reality of it is that the matter has been set. So why? I just wonder why the prosecution has waited so long. So, like any motion that's filed, there's usually a time period in which the defense can respond. Usually it's 14 days. Some courts narrow it down. It could be 7 days. Then if the court can't decide, like Judge Boyce has been unable to decide lots of things, they'll probably have a setting to set a motions hearing date with another motions hearing date. And if the defense can't get an expert funded in time to go there, whether it be at state expense for Daybell-Vallow or a private DNA expert for Chad Daybell, it could require a delay of the testing, and which could potentially require a continuance. Now, I'm not saying this is going to ruin the case for the prosecution in any way, but it really makes you wonder why the heck they've waited so long. Remember, they hired, Mr. Wood hired, I think it was Ms. Blake, right? Ms. Blake to come in and do, nope, that's not her. That's the other prosecutor. I can't remember her name off the top of my head. The one that from Missouri that they kept trying to get disqualified. Anyway, they hired her. It was her full-time job working on one case. And here we are 4 months going on, almost 4 months. Let's just say it's August 1st. 4 months until trial. 4 months. Yeah. I don't get that. I mean, seriously, I just don't get that. Can you hear the motion to continue being drafted right now? I can. I can hear him. Oh, Your Honor, test results haven't been done in sufficient time for the defense to review, analyze, consult with an expert. Because of the late testing, we would either ask for a continuance, or B, the exclusion of the DNA evidence. Boom. How many times have we said it on the show, Frank? How many times? More than I could possibly think of. If you want the prosecution. See, the prosecutors always think in a homicide case, let alone here you have a death penalty case, that there will be a continuance. And I'm telling you, I can think of 2 cases off the top of my head. We had it was a homicide case, and there was like a week left on speedy trial. And the court's like, well, judge, the prosecution wanted to continue the case. Maybe I guess there was 3 weeks. 3 weeks left in speedy trial. The prosecution wanted to continue the case, and they're like, well, judge, we're going to continue. Judge's like, oh, I'm going to grant it. Well, Mr. Rice, you and your client probably want to continue speedy trial, don't you? And give the prosecution another 6 months to complete their case. Yeah, nope, judge, we're ready to go. And then the court gets mad at you because then they have to, move stuff around in their schedule for the next 3 weeks that are booked. And you look and say, my client wants to go to trial. I don't want to tell you, Your Honor. My client doesn't have to waive his constitutional rights to accommodate your busy trial calendar. So be it. Went to trial. Prosecution wasn't ready. Key witness not there. Result, not guilty. Another case. Gang shooting, all this good stuff. Prosecution's like, oh, we're going to turn over all this stuff from this other case. And then you're going to be distracted by it and you're going to want a continuance. I spent all weekend reviewing it, going through everything, looking at it. Yep, not relevant. I'm prepared to try. You're not going to move for a continuance? Nope, ready to go. Even asked, well, I just want to put on the record, we turned over a lot of discovery for Mr. Reich's client. And, here, just making the record, Mr. Reich hasn't had it for that long. Ready to go to trial. 2 counts, murder, not guilty. Okay. The prosecution, and I don't know Mr. Wood, I don't know Ms. Blake, they may be fine trial attorneys, but they do not have a huge staff. They do not do murder cases on a routine basis. Certainly one of this particular nature of the, given the complexity of it, all of the digital forensic, electronic evidence that's going to be involved in this particular case, which is why they apparently brought in this, this other attorney. So yet here we are, 4 months from trial, 4 months from trial of a multi-death conspiracy homicide case, death penalty on top of that, 4 months from trial. And the prosecution doesn't have their DNA testing done yet. Like I said, is it enough for the case to fail? I doubt it. But it really makes you wonder when the case goes back to February of 2020. And I get it. It took a little over a year from the first charges related to the abandonment of Lori Vallow and Chad Daybell, Lori Vallow being charged with the abandonment of Tylee and JJ. All right, going back to February of 2020 and then indicted in May of 2021. It took a year. But like I said, when the prosecution, whether it be state or the federal prosecutors, they come and say, we have an indictment charging the defendants in this particular case, boom, speedy trial is a rolling. And when the prosecutors indict, they file charges, that means they're ready to go try this case right now within the speedy trial. Now, this has been delayed because Lori Vallow's been off getting restored to competency. Chad Daybell's attorney continued it several times because they wanted to get up to speed. I get it. Not going to blame them for that. But could you imagine when this indictment came back in May of 2021, if the defense had just simply said, not guilty? I mean, we have no statements other than, no interrogation to the police. It's going to be statements made to third parties that are going to be admissible by admission by a party opponent under the rules of evidence. But I'm not aware of any formal interrogation by any police authorities as it relates to Chad Daybell and Lori Vallow as it relates to this. They knew they had attorneys. They didn't interview them. What's the motions practice in that particular case? Not that much, right? Boom. Go to trial. You think the prosecution would have been ready? We already know they wouldn't have been. Now, I'm not rooting for Lori Vallow and Chad Daybell. I'm just saying, take a look at this, ladies and gentlemen. It's situations like this that does not always instill trust and confidence in your government officials. Just saying. And nothing against smaller town prosecutors. They're very fine attorneys. In fact, I've got my butt kicked in some small towns by the prosecutors. I once had a case, though. I had represented a medical professional on a case, and to say that I did not win that case on the merits, you would have to be very dishonest. But I lost the case. And as I was sitting there speaking with my client, explaining what he's going to have to do as far as his sentence goes, and he was kind of shell-shocked, like, dude, like you just beat the crap out of them. You don't get it. And I'm like, well, I know, but that's the problem. When you go to these smaller towns, a lot of times, these people in the town don't particularly love the prosecutor, but they're one of them. And they don't want some big city lawyer, not that I consider Denver to be any kind of big city whatsoever at all, coming in there and kicking the teeth in on their witnesses and making them look like a bunch of buffoons. You're kind of, making everybody look bad there, thinking they're all a bunch of hayseeds. I remember once I did a federal case in South Dakota, and I went in very nice to meet the lady, the U.S. attorney. How are you? My name is Scott. Pleasure to work with you on this case. It's going to be really good. And she looks at me and says, we're not all a bunch of hayseeds up here. And I was like, have I done something to offend you? Because all I've done is file an entry of appearance. I'm here for court. I'm here to introduce myself, to say I look forward to working with you. And she gets super defensive. We're not all a bunch of hayseeds up here. I'm like, I didn't think you were. I mean, you're a licensed attorney, all the rules. Why would I think otherwise? But then you get cases like this and you're just still wondering, like, why are they still waiting on DNA? And I get it. Sometimes the labs won't test. And I know this is for a fact, at least where I've practiced. The labs cannot test every single piece of DNA evidence. That's a fallacy that you see on TV, that everything just miraculously gets tested. No. One, there's not enough hours in the day to do that. And two, it's expensive. And so the lead investigators usually have to prioritize what item of evidentiary value do they think they have the best shot at obtaining something of evidentiary value, i.e. a hair follicle, a DNA sample, a finger, maybe some sweat or transfer from the DNA. So that they can do that. And then it's not like you put it in the microwave and do it. My understanding, it takes several hours from the time they put a sample in the machine. They recreate it, the little patterns, and then it comes down. Then they look at it and they analyze it. They look at the charts and they're like, oh yeah, here's one and there's one. And then they have to decide, is it a mixture? It's not easy. And so it takes time. And I understand why. I guess they've waited. Maybe they think they didn't need it, but this case is going to trial. It's the biggest case that I can recall ever coming out of Idaho. It's probably the biggest case any of the prosecutors have ever had in their days as prosecutors there in Idaho. You would think you would just plan ahead and say, you know what? I get it. This is a big case, but I'm not going to lose it. Spend what you need on it to make it happen. So, all right, there you go. I want to thank old Jackie R there for a $20 super sticker. Thank you very much. All right, let's do a quick reset. For those, I want to thank everyone for joining us. My name is Scott Reich. I am a practicing criminal defense attorney. I am the host of CrimeTalk, and we've been doing this for a couple of years now, and we do a Tuesday night show. We also put out a video just about every day, unless I'm in court. And, the last couple of weeks, I literally was June and July, I was supposed to be in courts nonstop. And then the case is resolved. And suddenly I was like, wow, I have some time on my hands. It's it's a little odd, but I'll take it. For so long, and then we went through COVID. There was nothing going on, and I had like homicide cases back to back, and I was supposed to be in a federal VICAR, which is the Violent Crime Street Acts, whatever it's called. Basically, it's federal court. If you're convicted of, basically racketeering activity with a violent crime, you could go to prison for the rest of your life. That's what the sentence was life. And the last time I had a VICAR case, I got it dismissed like a week before trial. They're like, yeah, we're not going forward. Oh, okay. Okay. Because my client was looking at life. Okay. And this one, they made us an offer we couldn't refuse. It's just, we couldn't refuse it. And so, these trials that I had were June, July, taking up 3 weeks at a time for preparation. They all went away. So it's been kind of nice. Not going to lie about that at all. I'm kind of enjoying it. But I find if I don't have my schedule packed full, I sometimes get a little lazy, but I need to recharge. And I don't know, the last couple of days I've just been tired. Probably all those birthday celebrations I've been having to go to, for sure. So that's what we talked about first. So that's who I am. That's why we are here. And like I said, the Lori Vallow case is always interesting. You never know what's going to happen. Somebody said in the comments earlier when I was looking at it on the video that we put up today, Scott, do you miss Mark Means? And yes, I do. And for those of you who are not familiar, Mark Means was the attorney that was hired by Chad Daybell to represent Lori Vallow. He, according to his website, is a predominantly divorce attorney. He says a little bit of criminal, but some mediation. And from what we can tell by his own admissions, at least by statements from the prosecutors, Mr. Wood in the case, was that he had never done a felony trial. So your first felony trial was a co-defendant homicide case with mental health issues and throw in a possible death penalty. To say that it looked a little amateurish, that it looked a little, like someone was drowning, get my head above water, would be an understatement. And it makes you wonder how long those competency issues existed, for at least what she was in the hospital for 8 to 10 months, I think it was. He had the case for right about the same time everything got started. So back in May of 2021, he got bumped off the case just prior to the indictments. February of 2020, he got on the case. May of 2021 is about the time that he got off of the case. And so, it was fun. I'm not going to lie. Just saying, what are you doing? What are you doing, Mr. Means? Mr. Archibald, who now represents Lori Vallow, obviously very experienced, and the motion that they filed last week regarding basically, hey, go back and do it right, because we're not sure what you charged. We think you got an elemental instruction wrong, and it's flawed. Now, the judge, we don't know what motions Mr. Pryor made or filed with the court as it relates to the grand jury deficiencies in regards to Chad Daybell, because remember, that was all in secret. So private, can't repeat anything. Oh my God, it's going to affect the outcome of the court. The trial is can't do anything. But Mr. Archibald said, hey, if you take a look at this, this just doesn't make sense, because there's issues here. You've charged like 5 statutes under the Idaho statute for murder. Is it murder plus this? Is it murder plus remuneration? Was it, they charged it really weird. It's like, was it 2 crimes consolidated? Is it 1 crime? Which could create confusion for the jury. And if they had charged by a complaint and information, a simple amendment could be done. We'll see if Judge Boyce digs into the analysis that Mr. Archibald did as it relates to that issue for Lori Vallow, and see if he thinks if it's worth fixing. If the indictment is defective, then the prosecution would have to reconvene a new grand jury, assuming the original grand jury is still not convened or still not together. I would believe that would be the case. So then they'd have to go back and basically represent all the evidence to the new grand jury to do a superseding indictment. When you have a superseding indictment, or an indictment, you have to supersede if you make changes. If it's a complaint and information, you can basically just file to amend the charges, and it's a lot easier. But then the defendant would be entitled to a preliminary hearing, which they're not entitled to if a indictment is returned. And it just depends. I had this case. It was bad. It was a cold homicide case. Tried this thing about probably 8 years ago, and man, was it fun. It was so much fun. And the prosecutors had originally an indictment and, say, hey, there was this murder going back 20 years from now, et cetera, et cetera. Well, then they superseded because they realized that they charged the wrong statute for the first degree murder that was in place at the time of the offense. So it came back as just a superseded indictment with 1 count, not the previous 6 counts. And I objected. I said, Your Honor, superseding, the plain meaning of the word says replace, to replace. And the judge is like, wow, I don't know. I mean, I think you can have 2 indictments. And I'm like, show me where you can. Show me where it says you can, the rules, Judge, because I couldn't find it. And I assure you, we looked. And we went round and round, and ultimately the judge was like, well, I'm going to go ahead and do it. So I'm like, okay, so we have an indictment and a superseding indictment, something that I've never seen in a state or federal practice on the same case. But the judge allowed it. Now, don't get me wrong. My client was accused of, 3 counts of murder, 1 count of attempted murder, and sexual assault. We didn't win, but it would start out as a death penalty case. It didn't go death. And it went up on appeal. And the appellate attorney, he was like, oh my God, this is the best issue ever. Scott, you did it. It was perfect. You preserved the issue. You objected right before trial. You objected every time. Hey, Judge, while we're up here, I just want to say that I don't think the court has jurisdiction. I object to the superseding indictment. I objected every time we went to the bench. Object. I preserved it. The appellate attorney was like, oh my God, Scott, you are the most brilliant trial attorney I've ever seen. You preserved it. Oh my God, it was great. And then the court issued its ruling under the SOB rule, which is your client was a son of a bitch, biatch. And said, well, it really doesn't matter. He's a bad guy. We can't let him go. A jury convicted him. Why are we so hard on the prosecutors? They're just trying their best. I mean, sure, you're right on the law, but we're going to make an exception because your guy's a bad, bad dude. I hate that. I hate that. And if anyone who's watched this show for a while knows that I hate that. That's why I get so upset when we read court opinions and they don't use the plain meaning of the language. Lawyers, words mean things. They have specific definitions. You can't just change the words because you want to, because it fits the result that you want. It is intellectually dishonest, and judges that engage in that intellectual dishonesty should simply resign and say, I'm done, because I don't want to be a judge. I want to be a politician. I want to be an advocate. I want to be an attorney again. Okay. It drives me absolutely nuts when Judges don't follow the law because they don't like your client. They don't like the result that's going to be given. And so they figure, hey, I'm going to rule against the defense and we'll let the appellate court sort it out and we'll see if they're wrong with me. Okay. Sometimes they come back and say, Mr. Reich was correct. Sometimes they say, Mr. Reich represented a total son of a bitch, and he may be right, but his client's too dangerous to be released. So we're going to issue an opinion, make this unpublished so that the world will never know that Scott Reich was correct. And it's just that his client was a terrible human being. Okay. It happens, ladies and gentlemen. And if you think it doesn't happen, I can give you specific examples. I know we've talked about this before, but I had a judge. It was a motion to suppress on a homicide case. And clearly the police procedures to impound the vehicle to then go get a search warrant, you had to do A, B, and C. And the police only did A and B. And I was like, Judge, it doesn't take a rocket scientist to say, if you look at their own rules drafted by their attorneys, implemented by their department, put forth by the chief of police to conform with case law that says you need to do A, B, and C. The police only did A and B, and you'd have to be an idiot to say that we shouldn't win. And the judge looked at me. She looked across and said, well, Mr. Reich, I'm not going to say your client is an SOB, but let's just face it. Maybe because of his facial tattoos, he's an SOB. But there's some case law out there that says the word and after the first two sometimes could mean an or. So, what do you have to say about that? And I looked at her and I said, well, Judge, I think that would be intellectually dishonest. When you look at the and the conjunctive and the or and the alternative, it's just wrong. It's wrong. Whereupon she basically looked at me like I had a third eye sticking out of my forehead, denied my motion to suppress, and the case proceeded to trial. So that's why I think it is so important when you lawyers and judges, and most particularly Congress or state legislators, draft legislation. Try not to get too tricky. Try not to get too tricky and think, oh, you know what? We'll just slam this through. Nobody will notice. And then it doesn't matter if we get it wrong, because the judiciary, they're in our pocket. They'll just ignore the rule of law and come up to the result that they want. We'll just make them a super legislator and say that the word or means the same thing as and everyone will be happy. Don't worry about it. Of course, it completely, you lose your faith in the judicial system when people on the court, on the bench, just make things up. All right. So if I haven't made it clear enough, words matter. The plain meaning of the words at the time they were written matter. You can't just change the meaning and what you think the word should be just because it fits your argument today. Bottom line. And it doesn't matter what the legislative intent was. It only matters what became law and what was put on the books that is at issue in the case. And always remember and never forget, you learned it here first, ladies and gentlemen. You're not going to find it in a law book. No judge is going to tell you about it. I told you. It's the SOB rule. Okay? Just like on post-conviction relief, I have an attorney here in the office, and he loves doing post-conviction relief. He thinks it's interesting, intellectually challenged for him. And I was like, hey, I understand you really like this stuff, and if you can get more work at it, that's great. I mean, helps pay your salary, all good stuff. But remember, the words of a judge that I liked and admired and respected one day as we were sitting there chatting and we were talking about post-conviction relief. And judge looked at me and said, Scott, um, you won't hear this in any rule book. You won't find it anywhere, but let me just tell you how it's done. A post-conviction relief hearing will be conducted when the Court of Appeals tells me, the trial court, that a hearing needs to be conducted, right? Trial courts don't have time for that and say, oh, look at that issue. We believe that there's an issue here, maybe ineffective assistance of counsel, unless it's absolutely glaring. The attorney has fallen on his sword and said, I was the most incompetent person ever to enter a courtroom. Probably not going to get a hearing up front. You're going to have to lose. Somebody files their post-conviction. And for those of you who don't know, post-conviction is when you've gone to trial, you've lost, you've appealed, you've lost your appeal. Then your next recourse is to say that everyone who's worked on my case up to this point, even though they put their heart and soul into it, was the biggest idiot I've ever known. And if I didn't have that biggest idiot there, I could have won this trial. It's the nature of the business. And when you do complex, high stake cases, and when I mean high stake, where basically people, their life is at issue, their liberty is at issue, their freedom, and sometimes in high stake civil cases too, people don't like to lose. They're never going to give up. Heck, they've got an entire lifetime sitting in a small 6x12 cell to think about it and come up for the reasons of all the things that the attorney should have done. So remember that. The SOB rule, it applies on appeals. It applies on post-conviction relief matters as well. So just remember that. You're not going to learn in a law book. You're not going to find it in a bar prep examination. You're only going to find this after years of practice, bottom line. Okay? If you've learned nothing this evening, you have learned the SOB rule. It'll carry you far in life. It is probably, people do it all the time in other industries as well. Yeah, we could probably help you, but you've been a real SOB, so we're not going to help you out today. Yeah, that's why you always be nice, right? Be nice. You don't want to do that. Clumsy clairvoyance. I like Mr. Pryor. He's captivating. Most disagree with me. It seems like a lot of people don't like Mr. Pryor. A lot of people think that he is somewhat arrogant. I think he has a certain swagger, confidence about him. And I've said this before, and I will say it again. I thought he did a pretty good job at the preliminary hearing way back when. What are we looking at? 2 years ago? 2 years ago. When Chad Daybell was originally arrested by the complaint and information member for the abuse of corpse and tampering with evidence stuff, I thought he did a pretty good job at the preliminary hearing. I thought, yeah, this guy's a trial attorney. So don't sell or undercut Mr. Pryor. I think, he's tried cases. And, compared to Mr. Means, he looked like a freaking rock star. And I think he's probably more of a, what's the word I'm looking for? He's going to be a little bombastic, a little outrageous, over the top, but sometimes you have to demonstrate absurdity with absurdity to make the jury understand that. I think Mr. Archibald is more of, I haven't seen him in court yet other than on Zoom, but he seems to be maybe a little more straightforward, get my points, argue to the jury with logic and common sense. Whereas Pryor's going to go out there and I think be a little more crazy, so to speak. Not crazy in a bad way, but, I'm just going to be a little more aggressive. He's got nothing to lose. Remember, his client is is facing the ultimate penalty in this case, death. So I think he's going to do everything he can. I think they've actually assembled a pretty good, group of attorneys, and it should be a pretty clear fight. I mean, I saw Mr. Wood at a couple of the hearings, very straightforward. Miss Lindsay Blake, I took some flack when I said, God, it seems like make your point and move on. And people are like, I mean, it looked like something from a moot court competition. These are all my points that I've written down, and I'm going to go through them regardless of whether I am winning. I am going to let the judge know that I went through all these things. And it's like, sit down, you're winning. Okay. Part of being a good lawyer is knowing when to shut up and sit down because you're winning. So we'll see about that. Let's see. All right, let's answer a couple more questions. Can't believe time goes by so fast some days. Man, it's just crazy. See, Elise agrees with me. Prior's good. I just let's see. Sleuthing Sandy says, I agree with Terry Martinez. I think both or all 3 DNAs is going to show up. Yeah, I don't know. There's one thing you never know about DNA. You never know if you're going to find it. Okay. There have been cases where I was like, the DNA came back negative? Really? Really? Because I got some kind of inside baseball information, like there should be some DNA right there. And other times you're thinking, wow, they shouldn't have found any DNA. Really? They found DNA? Really? On that surface? Wow, that's interesting. So I wouldn't get too excited about the DNA just yet. I think that we need to just wait and see. And even then, whose DNA? If it's Chad Daybell's DNA on his own work equipment found in his garage, means nothing to me. Means nothing to me. Simple question, Miss Expert in the DNA. When did that DNA get there? I can't say. It could have been years ago, could it not? Yeah. You have no personal knowledge as to whether somebody could have cut themselves removing a big old tree stump, or could have been burying bodies, right? Yep. Can't say for certain. Nope. Can't say within a reasonable degree of scientific certainty when that DNA got there. No, sir, I can't. All I can say is that's the DNA that we found there. That's it. Bottom line. So we'll see. The hair, I think, is a little more interesting. Whose hair? That's going to be the good one to watch, I think. If they can get DNA from the tape, think about it, tape. I was ripping some, duct tape this weekend, and, it's so sticky and you're fighting with it and you're like, argh. And I don't know if DNA would, definitively stay there. But you never know. I mean, DNA comes from your oils. It comes from the skin. It depends on the surface, right? The more smooth the surface, like this table, more likely if someone were to swab it, would find my DNA on it, versus if it was a rough wood substance. It'd have to be much thicker, like a blood type substance. But who knows? Like, oh, but we swabbed Scott's table and we found Scott's DNA. Well, wouldn't you expect it to be there? Of course you would. But I think the hair would be a little interesting, right? Let's say, for example, and I don't know how long the hair is, whose hairs it might be, but let's say it's Lori Vallow's hair, or Chad or Alex Cox, right? The deceased brother of Lori Vallow, who was apparently also into the same belief system that there were, dark spirits among these children. And I'm sure I don't have all the discovery, but it would seem as though that Alex Cox, Lori Vallow's now deceased brother, probably was involved in some way, if not the real killer in this particular case. And then you got a bunch of, so let's say it's his hair, his DNA. I mean, that is exculpatory, which means it would reduce the culpability or sentencing for possibly the defendants, right? If it comes back as Alex Cox, we didn't know. We didn't know. We didn't know what to do. We got scared, and then our lawyers told us to shut their mouth and blah, blah. And here we are. Alex Cox did it. I think you're going to hear Alex Cox's name come up once or twice. Now, you start getting into alternate suspect issues, and then it's going to be issue, do they have to give notice? But remember, the only thing the prosecution has to prove, the only thing, just a little bit of thing, right? Okay, it's a big issue. They have to prove that it was the defendants charged. Now, obviously, in this conspiracy counts, but it kind of helps when you name who the other co-conspirators are, not just others known and unknown to the grand jury, committed the deaths of JJ and Ty Lee, right? So I don't know. We'll have to see, because they have to prove that it was. It's like any case, any criminal case, ladies and gentlemen. Once again, something you're not going to hear. People spend years going to law school to learn this. And I'm going to tell you what you need to know. Okay, this is all you need. We've done this once before, I think. This is what you're going to need. It's all you're going to need. Fancy. All you're going to need to show in a court. This is any summary of any case. Okay. We do our loved sheets on every case, so somebody can pick it up and quickly read it. Location. What's the location of the offense? Why is that important? Well, they have to prove that it happened in the jurisdiction in which the case is being prosecuted, right? Why the police officers are always asked, sir, was this now and was it then in the blank city, county of blank where this case is being prosecuted? Yes, it is. The offense. What is the offense? I guess I could write that out there, right? Is the charge first-degree murder? Yes, it is. What are the elements of first-degree murder? That the defendant, right? The defendant, on or about the date and place charged, caused the death of another without legal permission, unlawfully, without legal permission, or after deliberation, or malice of forethought, caused the death of another. Boom. That's right. So the offense, they got to prove the elements. They got to be able to show a victim. Got to have a victim. Who's going to come identify the defendant in court? That's why DNA is so valuable in court, right? All these cold cases are filed after 20, 30 years because DNA evidence has become so good, was because before, murder's kind of hard to identify. Normally, think about it. Somebody punches me and I go to court and I say, I'm asked the question by the district attorney, do you see the man that punched you on the date on this date in the city of blank and the county of blank and the state of blank at the time of the offense? Yes, I do. Do you see that man in the courtroom here today? Yes, I do. Where is that man? He is sitting right over there next to the his attorney, and he is wearing the blue suit with the blue shirt and the red tie. Let the record reflect the identification of the defendant, right? Normally, you don't get that in a homicide case unless somebody does something in plain view, in public, right? You don't get it. So how do you prove, well, somebody's deceased? How did that injury get there? You pick the example. Didn't look like they did it themselves. Doesn't look like a suicide, right? Well, then they find the DNA. Well, they were there. It's consistent with that person being the last person to see them alive. So who's going to come identify the defendant in court? And then obviously the date and time. People have a right to know the date and generally the time when the crime took place. So if you have an alibi defense, the defense has an alibi, they can prove that. Okay. So remember, ladies and gentlemen, next time you got a case of interest, or maybe it's yours, who knows, you write out your loved: location, offense, victim, identity in court, and date and time. Who's going to come to court? That is one of the most important things, because they have to prove that it was the defendant. not someone that looked like the defendant, not somebody using the defendant's identity or doing something associated with the defendant. They have to prove that it was the defendant, or in this case, the Daybell-Vallow case, have to show that there was a conspiracy. And remember, most conspiracies are not written down. It usually doesn't happen. So you have to show that there's some agreement to do something. Well, guess what? Let's say the defense argues that there was no conspiracy between Alec Cox, the brother of Daybell-Vallow, and Chad Daybell. There was no conspiracy, never consented to that, would never agree to such a crazy thing. And everybody knows Alex Cox did it. Next thing you start raising a little reasonable doubt, can you not? Now, if I was a betting man, I would say that there was probably going to be a conviction. But the trial attorney is going to go in there and do everything they can to raise reasonable doubt. And I don't think this is necessarily a slam dunk. And what I mean by that is this is a case that has so many moving parts, has so much forensic data, that if the prosecution doesn't bring the right people, the evidence doesn't come in. Let me give you an example. Had a client, did a case, federal court, about a year ago. Okay. Pretty straightforward case. It was a possession of a weapon by a prohibited person. Basically a felon with a gun. All right. They pull the client over for whatever reason. Cops ask him to get out of the car. What's going on? Hey, we're going to arrest you. We're going to put you in handcuffs for our safety. We don't know what we're going to find. And sure enough, they just happen to find a firearm. And as soon as they see the firearm, my client, although handcuffed, dashes across the street. Running with hands behind his back. Dun, dun, dun. The SA doesn't get far. And it's all on body cam video. So this client's had some pretty good luck. We've done some pretty good things for him. And he says, you know what? I'm going to trial, Scott. I got faith in you. You got this. I'm like, really? He goes, man, you've always helped me out. Let's do this thing. Okay. So we go to trial. We're looking at the witness list, and they got that pesky DNA evidence because the DNA comes back on the firearm. And you're like, wow, that's not good. And we start looking at it. I was like, wow, they've only got the analyst that comes in and says, I've analyzed the DNA evidence and I have determined that it is 976 quadrillion to 1 that it's somebody other than, the defendant in this particular case. I'm like, okay. Well, where's the person that did the cutting? Huh. So I'm looking at they don't have this person either. They don't have this person either. Like, okay. So we go to trial. Ladies and gentlemen, my client is not guilty. All it takes is an allegation to get through those doors. Now the prosecution's got to prove their case beyond a reasonable doubt to each and every element of the offense charged. And ladies and gentlemen, when you hear this evidence, they are not going to be able to prove their case. So I want you to listen attentively and look at the evidence. Sit down. And of course, the prosecution gets up before I do because they go first. Our case is simple. Mr. Reich's client is a bad man. You'll hear that he admitted that he has a felony conviction, an element of the offense. And really the only issue is that he knowingly possessed a firearm. Pretty simple, right? Pretty straightforward. They're laying their witness. Cop says, yes, we pulled him over. We found a gun. I do my brilliant cross-examination. Sir, you pulled my client over. Who had the car the night before? I don't know. How many people were in that car? Oh, I don't know. Now, you made contact, and the people that you looked at the car and you kind of treated it as a felony stop. You were concerned for your safety, yada, yada, yada. You looked in that car when you first got it. Yes, I did. You didn't see any firearm. You did not immediately pull Mr. Client out of an innocent client to see it either. Well, I don't know. I don't know, but I did. But you didn't see it, right? I just want to make sure you didn't see it. Okay. And then they get to the good stuff, the DNA, and they bring in the analyst. Says, oh, I'm going to come in and say that there's 1 in 986 quadrillion that it couldn't be anybody other than him. Okay. Objection, Your Honor. Lack of foundation, personal knowledge. There's some case law out there that from the United States Supreme Court that says you get to cross-examine everybody involved in the testing to make sure that they performed it correctly. Noticed they have not called the witnesses who did the swabbing of the firearm, did the cutting of the swab, basically fancy word for putting the cutting of the little swab that they ran. It looks like a one of those pads people use to clean their face off with, and they test it in there. And then we go up there and say, Judge, they don't have the right person. And the judge looks at the prosecutor. And this judge was a former prosecutor, both the state and federal level. And he kind of looks at him like, what do you don't have the witness? And he kind of looks, well, no, Your Honor, what's the problem? I just got to sit there. Well, that case law, Your Honor, side pretty important. He goes, sustained. So we all go back, and the district attorney or U.S. attorney asks a couple more questions. Objection, sustained. The United States attorney gets up and says, Your Honor, we request a continuance. This is in front of a jury. Yeah, we request a continuance. And the judge is like, for what? Your Honor, so we can get the appropriate witness here. And the judge says, well, how far away are they? Well, I don't know, Your Honor. I'm going to have to call them and get them here. And then I kind of look, and I'm going to say, and the judge goes, they're not even on your witness list. And he looks at me, and I said, I agree, Your Honor. I object. And he goes, motion to continue denied. And the U.S. attorney, of course, they talk among themselves. Oh my God, what are we going to do? Oh my God, I thought you had it. Oh my God, geez, I could never thought of that. They try to ask one more question. Objection sustained. No further questions. Jury leaves. Motion for judgment of acquittal denied. Any evidence? No, Your Honor, we no, not going to do that. No evidence. I think I've won my case. We get up, we argue. They set my client free. And the point I make of that not is to say, oh my God, Scott, you're a brilliant trial attorney, which you are. Just kidding. But it goes to show that that was not even a very complex case. That was a 3 to 4 witness case. The Daybell-Vallow, Chad Daybell case, think of all the cell phone data. Remember the photographs that they got from the cell phone, the searches of Google. They're going to have to bring in all of those people to explain and to lay the appropriate foundation. And even if there's text messages, okay, and as I was explaining to a detective just last week, you would agree with me, although you say that the information came from an account that you say is associated with the defendant, you have no personal knowledge as to who actually wrote those words. Do you, sir? Well, I mean, it's her account. Sir, you don't know how many people have been admitted as admins on this page. You don't know how many people have access to it. You don't even have an IP address associated with this particular phone, or whether it's a desktop computer or anything of that nature. Do you? Well, no, I don't. So, sir, as you sit here today, you cannot definitively say who typed in those words that appear in that account. No, I cannot. Okay. So the point is that you have to realize they got a lot of moving parts, and there's a lot of moving parts that can go wrong. And if you miss a moving part, or you think, well, I don't need this little moving part because this other moving part should be enough. But guess what? If it's not, it's gonna get ugly for the prosecution. And the best way for the defense to win a case is if the prosecution is gonna look incompetent. So just saying, that's the way it is. Now, I don't know how the prosecution is going to do. I'm assuming they're professionals, and they're going to show up, and they're going to be ready just like any professional would. It is the biggest case of their career. They're probably going to over-prepare, which is another thing the prosecutors can do to lose the case. Present too much evidence, over-prepare, try to overthink every defense that the defense is going to try to raise. And then in their own time by doing that, they start creating reasonable doubt. Just saying. All right. Can you believe how quickly this night has gone? I want to thank everybody for joining us. If you'd like to continue the conversation, guess what? We will be going to our Patreon show here just momentarily. Probably going to drink some water, maybe hit a quick restroom break, and then we're going to do the Patreon show. But in the Patreon show, it's not just me talking. Guess what? You can call in to the secret undisclosed Crime Talk number, and we can talk about anything that you want to talk about. Somebody here had a question: is the case going to be televised? I do not know yet. I don't believe I don't believe that decision has been made just yet. Main Street Flamingo. I love a crazy good true crime, but the Daybell-Vallow case is making me tired. I understand. Sorry. It's turned into a snooze fest. I know, but I think it's going to get good here soon. We're 4 months away. 4 months away. And I'm not sure a lot of the prosecutors have ever done a death penalty case. I'm not even sure if a lot of them have done a homicide case, maybe one or two. With this much data from search warrants from so many different sources. And then you've got so many rules of evidence that are going to come in. Sit tight. I think it's going to get good. All right. Thank you all for watching. We appreciate you taking the time to do so. We know there's lots of other things you could be doing. It does not go without appreciation or thanks that you chose to spend your time with us. So thanks for watching. We'll see all of our Patreons in just a few minutes. And if you haven't become a Patreon, now's the time to do so you can join us, continue the conversation. We'll see you next time on Crime Talk.